hillbilly crime. You can't hide from hillbilly crime. You may not know that there's a crew in town. The head hillbillies are making their rounds. Small town whispers loud and clear. The sheriff shot the judge in his chambers chair. Sheriff got a secret he won't keep. Judge shot dead in his disbelief. A lot of people have some stories to tell. Dark pass away, get the sound of a shotgun shell. All the secrets spill on down. Voices loud in this old town. From the courthouse to the ground. Rumors fly and they can't be bound. Neighbors hide behind their blinds. Whisper tales of troubled minds. Skeletons covering the mountainside. A treacherous reality in the pines. Winter reveals the hidden lies. Moonlight couldn't mask the cries. Shadows caught in sunlit skies. There's no cover, no disguise. All the secrets spill on down. Voices loud in this old town. From the courthouse to the ground. Rumors fly and they can't be
Good evening. Howdy, y'all. How are you this evening? Everybody come on in. Come on in. We got some brand new information. We got several pieces of brand new information. But some of this stuff, it's old. It's really actually old. But for us, it's new. I sure never did know about it, I tell you. So, welcome in, welcome in. My name is Elizabeth, and this is Hillbilly Crime, where we are, honey, we are spilling all the tea. How are you guys? Happy Friday, happy Friday. I'm so glad that it is Friday. Yay! Miss Mary finally did the membership. Hopefully I can do bigger ones soon. Thank you. Thank you. We're so glad that you're here. Welcome to the family. Welcome to the family. We also have gift memberships. So anybody who can't become a member, gift memberships are really great. You can gift 1, you can give 5, you can 10, 20, and it really, really is a nice gesture, and other people really like it too. So we hope you will consider doing that. When I lived in Lexington, I never missed fall at Keeneland. It's beautiful, beautiful, beautiful. Yes. All right. Not everything is as it appears, you guys. hit that like button for us on your way in, if you don't mind. Now, the other night, we're going to do a couple things tonight. The other night, we started listening to the interviews again. So we got through one of Sabrina's interviews, and we're going to listen to one of Jennifer's tonight. And we're going to look at a couple documents. We're going to look at what racketeering is. So I don't know if you guys have heard people use the term RICO. RICO. It's RICO. I had this, I pulled this up. It's on an attorney's page. Daniel Stark injury lawyers, but still, it still tells us what understanding racketeering and RICO is. What does racketeering mean in criminal law? Racketeering is a broad legal term that refers to organized and ongoing illegal business activities. Okay. Now, the other night, the video where Gemma Bentley went on with Brian Enton, she came on and she made a comment. She said, it's not corruption, it is criminal. What they're doing is criminal. Well, it's both, in my opinion. I've said for a long time what they've been doing is criminal. And I think that all of them are guilty that are involved in any way, shape, or form in business transactions, or if they are benefiting from their clients in some way. If you're a defense attorney, or if somebody has hired you as an attorney to represent them in any kind of an action, a legal action, then you have a duty, which is why you have your license. You have a duty to that client. Now, I'm not an attorney, so I'm not trained in those things. But let me pull this up. Let me ask. I'm going to say, what are an attorney's ethical duties to their client? Attorneys have several fundamental ethical duties to their clients, including providing competent. Now, that's very important. Just because they passed a bar exam, just because they passed a test, that's no harder than what RNs have to pass when they go get their license, or any kind of nursing or healthcare, license that would take a couple years to get. It's no different. I think the only difference is that we keep electing lawyers to go represent us in Washington. They are the ones who have been writing the laws all these years. And so they have been very, very quick to regulate every other industry, but they ain't been so quick to regulate the criminal justice system. They've not been very quick to put any kind of regulations or I don't even know what the word would be for their compensation. There's no guidelines. There's absolutely no caps. There's no nothing when it comes to attorneys' setting their own prices and getting paid. So if you have a rural area that only has a few practicing attorneys in that area, then honey, they can set the legal economy pay for legal services in their area because they'll have the monopoly on it pretty much. I mean, people can go outside of that common or that local area and get representation, but the farther out you go, the more money that it takes. And the farther out you go, you're not going to be able to get any kind of fixers that are going to be able to come in and have those relationships with the judges. So it all works. You can't have one without the other. But hi, mommy, how are you?
I'm fine. How are you?
I'm good. I'm so glad that you're here. We're talking about understanding racketeering and RICO laws in criminal law. And I was reading something here. Um, I asked, what are an attorney's ethical duties to their clients? And it says that they have a duty including providing competent and diligent representation. Diligent, does that, I don't think that means that they don't show up to court. A lot of people have said, well, I hired so and so and they didn't even bother to show up. I wonder how much money they paid that person, because a lot of times, they don't do nothing for less than $1,500, and that's on the cheap side. Okay, it says maintaining strict confidentiality of client information, which, if they're telling things in secret behind closed doors, who's going to know, number one? And number two, even if somebody did know, how the hell are they going to prove it, and who's going to care? They could probably put in a bar complaint, but I guarantee you that ain't going to do nothing. So avoiding conflicts of interest. Well, that happens all the time. Communicating openly and honestly with the client and acting in the client's best interests while always adhering to the law, not acting in that own attorney's best interest professionally, because that's what I see happen a whole lot, especially with big cases. The bigger they are, the more impact they have on the attorney's reputation, their career, everything. So, and before now, you didn't have anybody in the courtroom watching. You didn't have anybody watching on TV or on a computer screen or on a phone. There wasn't any of this sharing on social media. So nobody knew about any of it. It was kept and I mean, it wasn't kept like secret, like top secret. Nobody can know. But they weren't out, screaming on the courthouse steps what they were doing. If you've been to court, the only people that are in the courtroom are the people that's got court. Okay. These duties are outlined in professional conduct rules to ensure trust and effective representation. Competence, diligence, and thoroughness. Competent representation, attorneys must possess the necessary legal knowledge, skills, and expertise experience to handle your case effectively, or they shouldn't be taking your case. Diligence. They are obligated to act promptly and with thoroughness in pursuing your case. Confidentiality and privacy. Attorney-client privilege. Lawyers must protect all communications and information shared by their clients, keeping sensitive details private unless the client provides informed consent to disclose them. I've heard time after time of people that had told me about when, like, old Daniel Dotson was their lawyer on something, and that a criminal case, a defense attorney, and that he would call them sometimes late at night, 10 or 11 o'clock at night, from the courthouse, and he would be up there in the judge's chambers with Judge Mullins, allegedly, and they were up there talking about the case and how they were going to handle it, and da 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 da. And that comes from several people who hired Daniel as their attorney. Well, why is your lawyer calling you at 10 or 11 o'clock at night from the judge's chambers with him and the judge sitting up there playing footsie under the table about your case? Allegedly. Well, that's not supposed to be happening. That's called an ex parte communication, and they're not allowed to have them. Period. But I'm not a lawyer, remember. So if I'm wrong, somebody let me know. But I don't think I'm wrong. Okay. The word originated in the 1920s when it was used to describe dishonest business schemes. For example, someone might create a protection racket where they demand payment from local businesses in exchange for not harming them. Over time, the term evolved to encompass different types of organized crime activity. Today, racketeering can include extortion, and maybe we need to also define what extortion means, because we're throwing around all these big words and all these big terms, and a lot of people, I don't think, even know what they mean. So extortion means the practice of obtaining something, especially money, through force or threats. So that could be votes, it could be money, it could be influence, it could be anything. It could be anything. It could be keeping somebody quiet who wants to tell something. Okay. Just, it can also, which is when someone forces another person to give up money or property through threats. It can also involve bribery, where money or favors are offered to influence decisions. There you go. Here I was looking for more, and I didn't even need to go anywhere more. This is plenty. Okay. So it can also involve bribery, where money or favors are offered to influence decisions. Money laundering is another common example in which illegal earnings are hidden or disguised to look legitimate, which I think happens here. I've told everybody from the get-go. Eastern Kentucky is the white-collar crime capital of the world. All they need are forensic accountants, and it is all right there. They weren't as good and I don't think they were. I don't think they were as good as what they think they were at hiding all this stuff because nobody was looking. They didn't think anybody was looking. I guarantee you they got sloppy over the years. What do you think, Mommy? You think people get sloppy over time when they're never getting caught?
Well, yeah, you start cutting short corners and you think, I guess you get to thinking that get a little God complex.
Yeah, you
Yeah.
do.
Mm-hmm.
Mm-hmm. Okay, it says, uh, finally, money laundering is another common example in which illegal earnings are hidden or disguised to look legitimate. Finally, illegal gambling and loan sharking have historically been associated with racketeering as well. There have been illegal gambling houses here, lots of them. But here recently, I mean, they weren't hiding them. One was right next to the rec center down there. Everybody knows where it's at. Half of the people in drug court have been going there for ever since it's been there. And old DD's been seen down there several times. Like, these people are gamblers. This is part of their lifestyle. It's not something that just happened overnight. No, they've been darkening these doorsteps for many years, and everybody knows about it. I can't tell you how many people in drug court have told me that they would be in there and look up and there's old DD looking right at them. They make eye contact and then they both just put their heads down and pretend like they never saw each other. Well, this is the same man that is over family court. He's the same one that's taking all of these people's children. Or, well, I don't know if he's the one taking them, but he's the one who's over it. So whenever one of his gambling buddies shows up over custody or whatever, guess who goes in front of Daniel? Well, do you think those women or the other party that's not his gambling buddy is going to come out on top? I don't know. And then we've got all kinds of real estate stuff that's popping up everywhere. So with the tourism and the real estate and Daniel Dotson being the master commissioner or whatever it's called, he's the one who sets up the sale of property on the courthouse steps. And then we've got a ton of like evictions, you name it, man. I just can't. There's so much crime that's been going on behind the scenes that has involved the courthouse and many different areas of the courthouse. It's astonishing. And we're getting all the proof.
Is that DD guy? I thought he retired.
Well, he did. From what I understand, he turned in his resignation and stuff, but he's been doing it for the last 20 or 30 years. So you can imagine how many people have been on the, wrong side of that, of those decisions.
Yeah, I was just thinking maybe my Alzheimer was kicking up.
Well, he's been seen down at the courthouse a lot recently. But I figure even though he resigned, he still probably had cases that he was involved in at that time. So I think he would probably have to finish up those cases before he could, dip out on them. But, I can't tell you how many people have told me about how they've been quit by just about all the attorneys that you see popular down there in Whitesburg. Somebody pay them and pay them and pay them, and then all of a sudden, peace out. But, all right, so we're going to move on to some of this new information that we found. So now here's one of them. All right. So we've got, this is a Social Security. It was a lawsuit against the Social Security Administration on behalf of Michael Clark. So the preacher man had, I guess, applied for his disability. And a whole lot of the things in here are just, this was before he got his job, his big job with ARC. So right before he got his big job with ARC, a couple years before, he was saying that he was fully disabled and he couldn't work. Very interesting. Okay. This matter is pending for consideration of cross motions for summary judgment filed by plaintiff Michael Clark and defendant Nancy Berryhill, acting commissioner of the Social Security Administration. Clark contends that the administrative law judge, the ALJ, assigned to his case failed to properly consider his subjective complaints of pain and other symptoms, and that the ALJ's decision is not supported by substantial evidence. The commissioner contends that the ALJ properly evaluated the evidence of record and that the decision should be affirmed because it is supported by substantial evidence. For the reasons that follow, Clark's motion will be denied. The commissioner's motion will be granted and the administrative decision will be affirmed. So he was denied for his Social Security. Clark filed a Title II application for a period of disability and disability insurance benefits, DIB, on December 5th, 2014, alleging an onset of disability of January 21st, 2014. Now, he only had like 3 coal mine jobs on his application for his pardon. Remember that? So I also think that we should pull up that pardon application, or let me see who else, who's on here that has it. Let's see. Let me send it. Oh, well, I'll just have to look it up. If anybody can look it up, I would like to know the dates on the education part of that pardon, because the information that I had on his work history with coal mining was that he worked for his dad. His dad had a coal mine business or something, and that he allegedly worked with his dad. And he was in active addiction, so he, was allegedly taking things that didn't belong to him from the business and was taking them and selling them or pawning them for drugs or money to get drugs. And from what the impression I got, or what I was told, was that they had to file bankruptcy maybe, but that they lost their business because Michael's addiction had stolen too much money or something. But I was told that it was a direct result of Michael's actions that the father's business tanked. The other 2 jobs, I don't think he did it for very long. Now, I could be wrong. We're going to look at the dates that he put in there. But I would venture to say, I would have to see pay stubs, because as many lies and exaggerations as what he does, just because he wrote something in a blank space doesn't mean that I'm going to take that and believe it. So I would have to see pay stubs to see and be able to add up the time, the proven time that he actually worked. And I'm sure the Social Security office would have needed those records. They would have required those records to be able to make a decision, you know, a legal decision on this. Okay. After being denied initially and on reconsideration, Clark requested a hearing. He appeared before ALJ Dennis Hansen at an administrative hearing on September 1st, 2016. So that's 2 years later. ALJ Hansen denied benefits in a written decision on November 2nd, 2016, which the Appeals Council affirmed. Accordingly, the claimant has exhausted his administrative remedies, and this matter is ripe for review under whatever statute. The background. Clark was 39 years old at the time of the ALJ's decision. He has a high school diploma and has attended some college. Guys, this is huge. Okay, what I'm getting ready to read is absolutely huge, and you need to be paying attention, because this is going to show you a lot of well, it's going to explain some things. Clark worked in underground coal mining operations from 2004 through 2012. Well, I want to see how much of that time he worked. So I don't believe it was full through. He was in prison some of that time, I'm sure. Or maybe he wasn't. Maybe prison time came after that. I don't know. But we're going to look and see. I'm going to find the dates, and we're going to compare and contrast them. Where he ran heavy equipment and lifted up to 100 pounds, he stopped working in 2012 because of back pain. Well, he put on his application that he stopped working because of his addiction. Addiction, not back pain. He didn't put on there he quit. He lost his job because of an injury. He didn't put on that pardon application. And you know, you have to sign that pardon application and swear that everything that you're saying in it is true and accurate. Do you think anybody, even if we found proof that he lied about anything, do you think anybody would take that pardon back because of a perjury? Or do you think they would even charge him with perjury? Why, hell no. According to Clark, his employer told him that he was no longer keeping up with the other men. Maybe that was because he was high all the time. He reported that he had been forced to reside with his parents after the loss of his job. Now, was he forced to reside with his parents because he lost his job due to an injury? Or was he forced to reside with his parents because of his addiction? Clark, now this is, you all, this is a civil suit with Social Security. This is a law, a court of law. Isn't there a guy, an attorney right now in some really hot water over the dust mask settlements? We've got an attorney in our area that did dust mask settlements. Matt Butler, he did a whole lot of dust mask settlements. He got a lot of people a lot of money. too. I wonder if that's why he sealed his divorce settlement. I bet it is. I bet it is. I would love to see a lot of that dust mask work, legal work. All right. Clark advised the ALJ that his most significant problems were low back pain and numbness in his left upper extremity. Well, honey, he must have done a complete turnaround since this, because I see him jumping up and around and carrying on like he was a baseball coach. Tom Vicini gave him his little league baseball team, and he was a head baseball coach for like, what, 2 or 3 years there. He didn't do it for very long, just long enough to, impress some big people. He stated that he was unable to hold anything. He was unable to hold anything. What? And that if he moved his neck in certain positions, it caused sharp pains to shoot down his legs. I've heard a lot of people say that just because I say it. And I've heard a lot of people say it, maybe if I say it too. Clark estimated that he could lift 10 or 15 pounds, and that he could stand for 15 to 20 minutes before changing positions. Well, he gets up in front of them churches and preaches all morning and night, don't he? He's traveling all over the country. They said he had done preached in 10 states by the time he got his pardon in 2019. That was on his application, that he had done preached in 10 states. Well, somebody who can't work, who can't hold anything. Very, very telling, isn't it? Isn't this very telling at the character, the personal character of who seems to be a magician? He has all the answers for addiction. He has all the answers. All you got to do. Did you see the thumbnail? Did you like his outfit? All you got to do is call the Clark man. Call the preacher man. He'll save your soul. Clark claimed that he was unable to drive due to limited neck motion. Heck, he couldn't even drive. But yet he's getting a car paid for. I got a little information. A little birdie came and talked to me about that today too. Yeah. I don't know if it's true or not, but so from what I was told about the car, that a man, now this is alleged, it was just a little piece of information that was told to me. Don't know if it's true or not, but could be. Says that a man named Dan Spurlock, who is associated with the organization sigco.org, called Brian Redmond, who's a former managing partner at Tim Short Auto in Middlesboro, Kentucky. Middlesboro is down towards the central Kentucky, down at the bottom. So as you go out of Middlesboro, you can go through the tunnel and it takes you right into Tennessee. So it's right on the Tennessee line. Now it's called Redmond Auto Group. And this was around 2018-ish. And the guy called to inquire about helping Michael Clark out with a car. It's very interesting. I heard that Mr. Spurlock was also Brian Redmond's pilot, airplane pilot at that time. Mr. Spurlock allegedly also invited Mr. Clark to speak at a church that he was a member of in Virginia before making the call to the dealership. Nothing like having friends in all the right places. You come preach at my church, honey, I'm going to buy you a car. I mean, what kind of church and preaching are we talking about? Clark went and preached apparently at Sheriff what's-his-name in Hazard, Perry County. I don't remember his name. Engel. There it is. Sheriff Engel. Clark went and preached at his church, and guess what? He got a letter of recommendation for a pardon request. I wonder what other kinds of favors are floating around these churches. Seems to me that's how they've gotten their snakes in the door. The plan, think about it, the plan was perfect. They'd go to Clark and say, hey, we can make you a chaplain. That's how we can get you paid. We can make you a chaplain. All you got to do is be a preacher. So Dave, old brother Dave, takes him to a church service and he preaches. Brother Dave preaches. Nothing like sucking them in, ain't it? And the next day, that night, Clark gets saved. He goes to the altar and gets saved. He's ready. After all these years, he didn't want nothing to do with God. God wasn't no friend of his. And all you got to do is listen to the man's own sermons. And you get all the information that you need. Now, I've been in church. I've sat under a lot of preachers. I know there ain't nobody that, number one, doesn't seem to have ever cried out to God a day in his life. Didn't want nothing to do with him. It wasn't until after prison. Now, he went all the way through prison and didn't want nothing to do with God. It's only after prison that this scheme starts putting into place. They needed to fill a role. And he's a really good actor. Or at least he thinks he is. I just look at him and my whole body starts convulsing. That's the Holy Ghost. So Clark, his employer told him he was no longer keeping up with the other men. He couldn't hold anything. He couldn't stand. He couldn't even drive a car, you guys. Now everybody's falling all over themselves to buy him a car. Somebody who 2 years, 3 years before he got his pardon. This was 3 years before his pardon. He couldn't even drive a car. He reported taking several medications to manage his symptoms and had a history abusing pain medications. Clark advised that he had to lie down and elevate his feet to relieve his symptoms 6 or 7 times each day. Clark reported to Appalachian Regional Hospital, ARH, Tri-City Medical Center on January 10, 2014, where he established care with Joanne Martin, nurse practitioner, and his primary care provider. So he was going to Whitesburg. Is that Whitesburg? ARH, Tri-City Medical Center. I don't think it says. Not yet, anyway. He told her about his neck pain, his back pain, and that he got hooked on Percocet and had been going to a Suboxone clinic for a year. Martin referred Clark to physical therapy. He continued to follow up with Martin, advising her in February and March 2014 that he needed a work excuse. Martin advised Clark in June 2014 that pharmacies had notified her that he had prescriptions for Neurontin filled by 2 different providers. He knows the ropes on filling medicine. He knows, and he knew it then too. We all did. They started that Casper. Casper, years ago, they called it doctor shopping. Though they still call it that. But back then, you got to remember this time period, the internet had just really gotten big in the last couple of decades, or in the last 20 years. So you had this huge influx of technology that hit. And before, they couldn't really keep up with that stuff. So you had people that doctor shopped. They went from one doctor to the other, getting all these prescriptions, the same things, and then they would go get them filled. So they started this Casper system where they could run all the medicine, run you through this system, and it would pop up every prescription that you had filled and in what pharmacy, and it would, tell them, of course, what doctor it was and whatnot. And they started charging people criminally with that, with doctor shopping. And so everybody that was an opioid addict knew everything about doctor shopping. We all knew about the Casper. The task force that came through here, the United Operation Unite task force, they made everybody aware of all the tricks of the trade. And that was back in the 90s and the 2000s. So he was very well aware in 2014. And I think that's very interesting that he would have been in a Suboxone clinic. So he wasn't going through any withdrawals. I'm an expert on Suboxone. I will claim to be an expert. Yes, I will. But I find it very telling that he was trying to sign up on a check. He was trying to get his check at such a young age when we've got all these people in this area who fraudulently sign up on a check. He wasn't no different. He didn't deserve disability. He was scamming the system like so many others do, or at least he was attempting to, allegedly. It's what it looks like to me. So she notified him that about the prescriptions. Martin ordered a drug screen, and it does not appear that Clark returned to her after that. So once he got caught, he just bailed. He didn't even finish. He didn't even go back to her for his Suboxone. What's that tell you? That tells me a lot. Clark, this whole thing tells me a lot. Wait till we get to the next one, because the next one is even worse than this. Clark was involved in a motor vehicle accident on or about January 21st, 2014, and was transported to ARH in Harlan, Kentucky. He reported that his car slid on ice and overturned, and he tested positive for cocaine and benzodiazepines. So that's Xanaxes or something like them. So he was on snowcane and benzos. A CT scan of his head was normal. But yet, he needed his disability. He can't work, but he can drive a car on snowcane and Xanaxes and put other people's lives at risk. But a CT scan of his neck showed signs of degenerative disc disease at C5 and C6, and I think, honestly, a whole lot of us do. I know that if you go to a doctor and have a scan done and you are 40 years old, you're going to have some, I hate to tell you, with mild encroachment of the neural foramen on bilaterally. A CT scan of Clark's left leg revealed a contusion, a bruise, and an x-ray of his right shoulder was largely unremarkable. Clark began physical therapy treatment in February 2014. He advised his therapist he had pain in his neck, his back, right shoulder, and left Achilles region, which he rated 10 out of 10 at its worst. That's an addict if I've ever heard one. What's your pain level? 10 out of 10. It's a 15. But yet, my 14-year-old child had surgery and had his gallbladder taken out and didn't even take Tylenol. But another lady just talked to me the other day, and she had this great big surgery, and she wasn't taking nothing but Tylenol. Us that are on Suboxone, we'll never be able to take pain medicine for anything. Not as long as we're on this. It's got a blocker in it. So I think that's really funny when they say, oh, look at her, she's high. She's nodding out. What am I nodding out on, dude? I mean, stupid. This has a blocker in it. So even if I wanted to take something, it wouldn't do nothing. Clark, let's see. His gross strength was slightly diminished, particularly in the right lower extremity, and his neck range of motion was reduced. Well, he couldn't drive a car. Well, what was he out driving that when he wrecked then? If he says he couldn't even drive a car and had no motion in his neck. But I deserve my Social Security. I deserve my disability because I was out driving around on snow cane and Xanaxes, and I wrecked my car and flipped it. So I'm injured, and I need Social Security disability. Pay me a check for the rest of my life. Let the citizens, the taxpayers, support me for the rest of my life. Well, now look at him. Now he's begging all these church people, taking in all these donations, and then turning it into the IRS that he took a loss. Yeah, I pulled up these Michael Clark Ministries 501c3 tax papers. He said he lost money. He didn't even get enough money that year to stay above the red. Do you believe that? For any year that he's had Michael Clark Ministries, do you think for a second that he lost money? He was in the negative. That's what it has on there, that he was in the negative for the entire year. I don't believe it. I don't believe it. I don't know why they needed it to say that, but apparently I think they've needed it to say that for some reason, for some other larger purpose. We're going to figure it all out. This is one piece at a time. We're putting the puzzle together. Clark still demonstrated strength and range of motion limitations and complained of 10 out of 10 pain in April 2014. A May 2014 MRI of Clark's cervical spine revealed a moderate-sized central disc protrusion herniation. An MRI of the lumbar spine in June 2014 indicated mild diffuse annual bulging, but there were no signs of herniated nucleus pulposus or spinal stenosis. We're going to have to put that in the cartoon. It rhymes. Take mental note. Finally, an MRI of Clark's shoulder in May 2014 showed mild hypertrophy of the AC joint, but no signs of a rotator cuff tear were identified. William Rigsby, PhD, performed a consultative psychological examination. Here it comes, y'all. Here comes the good part. We've got a psychological exam on the preacher man. Of April 28, 2015. Clark advised Rigsby that he had experienced panic attacks and nervousness since 2010. Well, I wonder what happened in 2010. Why would they be triggered? Anxiety and panic attacks and nervousness since 2010. Like, why did he say that? What was significant about that year? What caused the attacks? These alleged attacks. He reported having chronic pain and participating in his 6th substance abuse treatment program. Rigsby noted that Clark related in a cooperative manner, but appeared to be from a deprived background. A deprived background. His daddy owned a coal mine business, and his mommy was a nurse. They lived in a big brick home, and they were not financially lacking anything. Okay. But he appeared to be from a deprived background and was somewhat limited and below average, but not mentally retarded. This is who y'all are sending your money to. He appeared to be from a deprived background and was somewhat limited and below average, but not mentally retarded. He had intact short-term and long-term memory and was able to perform simple math and reasoning. Rigsby assigned Clark a global assessment of functioning, a GAF score of 65, but indicated that he had a moderately impaired ability to understand, retain, and follow simple instructions. And to sustain concentration and persistence to complete tasks in normal time. Let's reread that, shall we? Indicated that he had a moderately impaired ability. Moderately means, let's look it up. Okay, what's the definition of moderately? Oh no, honey, we're breaking it down. We ain't skipping over this stuff now. Moderately, to a certain extent, quite and fairly, in a moderate manner. Growth continues moderately, within reasonable limits. Both hotels are moderately priced. To a certain extent, quite and fairly. So I guess that would be, let's see, what's a synonym for it? Moderately, synonym. Somewhat, quite, let me open this up. Pretty, relatively, quite, somewhat. Some of them don't apply, like deadly. Significantly. Okay, so that's a good synonym. So that he had a significantly impaired ability to understand, retain, and follow simple instructions, and to sustain concentration and persistence to complete tasks in a normal time. So he had a substantial impairment that caused him not to be able to do these things. Meaning he can't hold a job. He can't work. Are you kidding? But yet he seems to be getting all kinds of work these days now at the Beacon of Hope. And you know what kind of BS that is? I know that there were other applicants for that job he got. And they passed over someone with a woman with a master's degree and a whole lot more experience than he's got. And they hired him over a much more qualified applicant. Sound familiar? It must be nice when people just give you a job. And then he goes around acting like he's so poor that he's just going around preaching all over the country, volunteering, taking on all the cost. Well, let me tell you something. That ain't what a preacher does. That ain't what they do. They don't go around and say, hey, if you if you'd like to donate to me, you know, because I take on all these costs myself, and, you know, that ain't what they do. If they felt led to go guest preach somewhere, then they get in their car and they go. They don't beg and borrow money to get there. They rely on God to provide, and He always does. He always does. It's about faith. It's about building your faith. My pastor one time, he would always tell the story, because he'd always go visit people in the hospital whenever they were sick. Everybody. It didn't matter who it was. If he heard you were in the hospital, he was coming by to see you. And him and his wife, there was somebody in the hospital. They needed to go see them and pray over them. They didn't have any money and they didn't have any gas in their car, but they had to go to Hazard, which is about 40 miles, 40 minutes. It takes about 40 minutes to get there. Said the light was even on in their gas tank. They got in the car and they drove all the way there and they drove all the way back with the light on, the gas light on. That experience grew their faith exponentially. I had an experience like that, but I wasn't going preaching somewhere. I was out lost in the middle of nowhere with my gas light on, and God let me drive for over an hour with my gas light on at midnight with 2 babies in the back seat, and there wasn't a gas station nowhere. You know, those kinds of things are just, that's what Christians do. You build your faith with stuff. It ain't that we perfect. We ain't got the answer for nothing except point you to Him. It ain't all about, oh, look at me, look at me, look at me. But that's just my opinion. And everybody's got one, but that's my take. All right. Clark received an independent psychological exam from Robert Spangler, ED, on November 10th, 2015. So this is another one, another psychological exam. Spangler observed that Clark had a slow, stiff gait, awkward, gross motor movements, and slurred speech. He also noted that Clark was shy, vigilant, anxious, and depressed. Clark was appropriately persistent on tasks with prompts, but his pace was impacted. He appeared to lose his balance when standing, shifted in his seat frequently, and mumbled constantly. Spangler reported that Clark had adequate recall of remote events, but inadequate recall of recent events. His judgment and insight were consistent with average intelligence. His stream of thought was unremarkable. His associations were logical, and his thought content was non-psychotic, but was focused entirely on his injuries and pain. That's an addict. But, you know, he's been clean for 9 years. He's been sober for 9 years. We're supposed to believe that. He never relapsed. He ain't never had no problems. Honey, whenever he started working at ARC and started preaching, his whole life just changed. He went from not being able to work a job, and I could go on and on and on and on and on, but I do that too much. So let's get back to this. Spangler noted that Clark interacted well during the exam, but he reported that he stays tired and goes into rooms and forgets why he is in there. Join the club. We all do that. I mean, I don't think that I need to be on disability because I do that. And, you know, if you've had a lifetime of drug abuse, You know, some of this stuff is just age, too. Spangler administered the personality assessment inventory and concluded that all clinical scales were within normal parameters except anxiety, which included subscale scores confirming Clark's diagnosis of major depressive disorder, generalized anxiety disorder, and being an individual with drug dependence who is in treatment and who acknowledges the need to make changes and accepts personal responsibility. ALJ Hansen, I'm just going to move right on past that, determined that Clark did not have an impairment or combination of impairments that met a listing under whatever. However, he concluded that Clark had the following severe impairments: degenerative disc disease, affective disorder, anxiety disorder, and personality disorder. After considering the entire record, the ALJ found that Clark had the residual functional capacity to perform light work as defined, except he was limited to occasional climbing ramps or stairs and occasional stooping, kneeling, crouching, and crawling. So does that mean he got his Social Security? Is he on disability? I don't think so. It was denied, wasn't it? But I don't know. It may have just been his hearing request that he, or whatever it was he was asking for, was denied. I don't know. But why are they saying he has limitations then? He has limitations for work? So they tell him that's what he's got? He can only partial work? He can never climb ladders, ropes, or scaffolds, and never be exposed to unprotected heights, dangerous moving machinery, or operate motor vehicles at work. The claimant is limited to occasionally reaching overhead. He can understand and remember simple instructions and can sustain attention and concentration to complete simple tasks with regular breaks every 2 hours. He can occasionally interact with supervisors. What the hell? He can occasionally interact with supervisors, I guess because he's just so fragile emotionally that he just can't take it. Any kind of supervisory critique or pressure. What? Why can't he? Why can he only occasionally interact with supervisors, co-workers, and the public? He was a community liaison. So they're saying that he can only occasionally interact with supervisors, co-workers, and the public. Are you joking me? Do you all see what a freaking liar that fraud this man is? And then after this, he gets this big job and just takes off like a superstar. Superstar. All I see is SNL, Saturday Night Live skits playing all in my head. Preacher superstar. You know, one scripture that I will quote says, "It is better to wrap a millstone around your neck and throw yourself into the ocean than to make one of God's little ones stumble. I rebuke the devil in the name of Jesus, Lord. I plead your precious blood down over top of us, Lord. I pray that you continue to expose these false prophets, that you show the people that are being deceived and help them, Lord. I pray that you drop the scales from their eyes and allow them to see what's plainly in front of us, Lord. Oh, hallelujah. I praise you, Jesus. I praise you, Lord. I pray that the Holy Ghost moves. Oh, hallelujah. Thank you, Jesus. In Jesus' mighty name, man. He can adapt to routine work conditions and occasional work changes that are gradually introduced. Only gradual changes, you guys. He cannot handle any kind of change. I am just in like total BS detector mode. I've been in BS detector mode with this fool. Based on the above reference, the ALJ determined that there were jobs existing in significant numbers in the national economy that Clark was capable of performing. Yes, he is. Accordingly, he concluded that he was not disabled under the Act. Way to go, ALJ. That was a good decision. I agree with it 1,000%. Under the Social Security Act, a disability is defined as the inability to engage in substantial gainful activity because of a medically determinable physical or mental impairment of at least 1 year's expected duration. A claimant's Social Security disability determination is made by an ALJ in accordance with a 5-step sequential evaluation process. If the claimant satisfies the first 4 steps of the process, the burden shifts to the commissioner with respect to the 5th step. The claimant must first demonstrate that he is not engaged in substantial gainful employment at the time of the disability application. Second, the claimant must show that he suffers from a severe impairment or a combination of impairments. Third, if the claimant is not engaged in substantial gainful employment and has a severe impairment which is expected to last for at least 12 months and which meets or equals a listed impairment, he will be considered disabled without regard to age, education, and work experience. Fourth, if the claimant has a severe impairment but the commissioner cannot make a determination of the disability based on medical evaluations and current work activity, the commissioner will review the claimant's residential function. Okay, we don't need to read all that stuff. Counsel for Clark made a similar argument in London civil action. The court issued a memorandum opinion and order in that case, which eliminated use of the term credibility, explaining that ALJ still must consider possible reasons why a claimant failed to seek medical treatment consistent with degrees of complaints. So Clark contends that the ALJ did not apply proper legal standards in assessing his subjective complaints of pain and mental limitations. So Clark was the one who was raising those mental limitations. Clark was saying himself that he was mentally and physically disabled. But the court did not seem to agree with him. Um, to the extent Clark's statements regarding the limiting effects of his pain and psychological symptoms were not substantiated by objective medical evidence, the ALJ was required to consider other evidence in the record to determine whether Clark's symptoms limited his ability to perform work-related activities. The ALJ looked at factors including Clark's activities of daily living, the location, duration, frequency, and intensity of his pain, precipitating and aggravating factors, the type, dosage, effectiveness, and side effects of medications taken to alleviate the pain, treatment other than medication for relief of pain or other symptoms, and any other factors concerning functional limitations and restrictions due to pain or other symptoms produced by medically determinable impairments. The ALJ noted that Clark reported being able to drive, talk on the phone, shop, and sometimes attend his child's ball games. Well, he became the head coach. How many years after this that he said he couldn't even walk or drive a car? You mean Tom Pacini? You mean Tom Pacini would help on something like this? You think he would even be associated with it? He's just such a big man of God, you know, and everybody just thinks Tom Pacini wrote the sun rose and set in him. But yet he wouldn't even crack the door open to let me have a job as a custodian. He wouldn't help me to save my life. No, but yeah, he sure would. Clark, he'd roll out the red carpet for him. It just makes you wonder why, doesn't it? Like, it just makes me wonder why. Why such a difference in how they treat people? Like, what about Clark was so amazing and achieve? Like, what did he achieve that was so wonderful other than he claimed that he was he turned his life over and got saved? I think that we have become so accustomed and conditioned to not ever question anybody if they say they're a preacher. If they get up on a stage and they say they're a preacher and they say they're a man of God, then how dare anybody question anything that they do? I mean, they can get caught out in the parking lot kissing on another man's wife while his own wife is sitting in the front pew with the children. Oh, yeah, I know one of them. We could go, listen, we could really go on and on and on. I had one of our own elders at my own church. Now, I don't care if he was getting old and senile. I don't care. He still walked up behind me in a prayer circle at the front of the church and pressed himself up against me. So I'm standing up there with everybody else, and we're laying hands on somebody and we're praying for, healing. And all of a sudden I feel somebody behind me pressing their self up against my hind end. And I just froze. I just froze. I didn't know what to do. And to beat it all, his wife was sitting 2 rows back. Never said a word. Now, I immediately moved after I could get a hold of myself. And I was traumatized, absolutely traumatized. I stayed after church and told my pastor what happened. And my pastor, I loved my pastor. He passed away at COVID, but I loved my pastor. But do you know what he said to me? I didn't like what he said to me, though. But I had to accept it. There wasn't nothing else I could do. He said, well, the next time that we have prayer, just hang back and wait and see what side he goes to, and you go to the other side. Now, I didn't like that answer, but I took it. 6 months later, maybe, we go in church, and he goes to give, and you go around and you shake everybody's hand and you give them a little hug and say good morning and all that stuff. And we had been to church together for 10 years. Like, these were people that I knew very, very, very well. And he goes, we go to, kind of do like that. And I wasn't getting too close. And I had a dress, and I've never dressed inappropriate, ever, ever, ever. Trust me, I know exactly what inappropriate is, and I don't ever do it. But the skirt that I had on was a very long, it hit the floor. It was a long skirt. And on the side, it had a little slit on the bottom that was only that long. It wasn't long at all. It was very short. And he says, glad to see you came to church half naked for me this morning. Like, where did that come from? So, there was a part of me that wondered, and he was getting sick, and there was a part of me that wondered if it wasn't like some kind of senility happening. But I was offended. I was traumatized having him come up to me like that in the prayer circle and pressing himself up against me that way. I felt assaulted all over again. Like I was immediately a little child in my emotions at that point in time. And I told my pastor about that too. But the old man ended up dying like a year later or something. COVID hit right after that. And I just never did go back, honestly. That was a very big lesson for me, that even people that I knew, that I thought I knew very well, nobody's perfect. And a lot of times people can put a mask on every Sunday morning. You just see them Sunday morning. You go to church with somebody your entire life. Scott Blair, the prosecutor in Perry County, is a perfect example. That man went to church and had 200 church members write letters of character in support of him from the church. Now, I guarantee you those defendants that he was making, giving sexual favors and bringing drugs, I bet you they weren't writing letters in favor of him at his sentencing. If we're not real careful, these people, these snakes come in, and they become preachers because they love that 501c3 status. They can be tax exempt. They can use that status for all kinds of things. And they can also use their connections in the churches. Oh, let's look at this big baby. This is the, honey, this is it. This is the big one. United States of America versus James Jackson. United States of America versus Anthony Clark. Michael Anthony Clark. This is an appeal, on appeal from the United States District Court for the Eastern District of Michigan. You see that? Eastern District of Michigan. Oh, you all, we have not seen any of this. This is going to rock y'all's world. So what do you all think when you hear drug trafficking? Do you think that they're down on the corner? Do you think old Clarky Poo was down there on the corner selling a little $5 bag? Well, let's find out exactly what kind of duties and activities come along with drug trafficking. Let's see. I'm not going to get into the legal aspect of it because I don't care about that. I don't care. He's got a pardon. Well, that's a Kentucky pardon. I wonder about Michigan. Somebody look up Michigan for us, and we're going to dig those legal papers out. If we can get public records request in on this case, anybody that wants to take down the case number, which this is a appeal, so there should be a ton of documents regarding this case. All right. The indictment named both defendants plus other co-defendants who elected to plead guilty rather than go to trial in multiple counts. Clark faced 2 counts of conspiracy to possess with intent to distribute and to distribute controlled substances. Count 1 for marijuana, count 2 for cocaine. A continuing criminal enterprise. You know, who better than to bring on into a criminal enterprise than somebody who already has the experience? You wouldn't want to bring in somebody who don't know what they're doing. You want to bring in somebody who knows every trick in the book, don't you? Count 4, 7 counts of unlawful use of communication facilities to conspire to possess with intent to distribute controlled substances. Counts 5, 6, 7, 9, 11, 13, and 33. 1 count of conspiracy to launder monetary instruments. There's the money laundering aspect of Preacher Man. Yeah, this is Preacher Man, you guys. This is Preacher Man. I bet nobody knew about this, did they? No, because this wasn't in Kentucky. This is Michigan. One of his, he was an interstate trafficker. Michael Clark is and has been, allegedly, I guess I better throw that in there, even though he was convicted. So, how come he wasn't facing federal charges? Huh? Where's the federal charges? Where's the feds? Honey, they were bringing it in 18-wheelers. Oh, Clarky Poo is ordering hits. He's involved with hitmen, ordering 3 hits on an informant. Oh, who thought Michael Clark was some little... we just read all kinds of stuff from the Social Security and the psychological analysis. He couldn't even drive a car, you guys. He was not quite mentally retarded. I didn't even think they were allowed to use that word anymore. But they used it for him, saying that he not quite mentally retarded. But yet this fool was involved in an interstate drug trafficking, organized crime enterprise. Oh, wait, it gets good. Oh, it gets good. So 1 count of money laundering, 2 counts of felon in possession of a firearm, and 2 criminal forfeiture counts. That means money. I guess. I don't know. Honestly, I don't know what that means. But we're getting ready to find out. Jackson faced 1 count of conspiracy to possess with intent to distribute marijuana and 2 counts of unlawful use of communication facilities to conspire to possess with intent to distribute controlled substances. So it sounds to me like Michael Clark got the majority of these charges. You know why? Because they had an informant. Oh, Clark got took down by a rat. The jury found Clark guilty, so he went to trial. I want the trial transcripts. I want everything we can get from this trial. So, my diggers, mount up. Hillbilly crime diggers, mount up. He was found guilty on 1, 2, 4, 5, 7, 11, 13, 33, 41, and 42 of the indictment, but acquitted him on the other counts. The district court sentenced Clark to the following terms of imprisonment, all to run concurrently, so that means at the same time: 480 months on count 1, 600 months on count 2 and 4, 48 months on each of counts 5, 7, 11, 13, and 33, and 120 months on counts 41 and 42. The jury found Jackson, okay, so the most was 600 months. So let me do the math here. 600 divided by 12 is 50. Is that right? What am I doing, guys? What am I doing wrong here? What math problem? Mommy disappeared. She got on there and disappeared. She gets bored with these kinds of shows. All right, so he got 600 months is what he got, and there's 12 months in a year. So did he get, I came out with 50, but he didn't get 50 years in prison, right? Is that right? 600 divided by 12? I'm waiting on one of you all to tell me. Hey, Zelma, Mommy, where'd you? Okay, so he was sentenced to 600 months. All right, so how do I do that math? Is it 600 divided by 12 to find out how many years that is?
Yes.
Well, that's 50. So would he have gotten 50 years? Yeah, that's what Minnie says 600 months equals 50 years. He got 50 years in prison. No. The appeal took some of it away, I think. Well, let's finish reading it, I guess. I haven't read it all. I just read the highlighted portions of it. Okay, the jury found Jackson. All right. First, Clark contends that the district court erred in denying his motion to suppress evidence obtained from a Title III wiretap, where the motion alleged that the wiretap affidavit failed to demonstrate probable cause and necessity under that statute. When reviewing a district court's ruling on a motion to suppress a wiretap, we consider factual determinations under the clearly erroneous standard. The district court properly denied Clark's motions to suppress, finding both probable cause and necessity. A judge may properly enter an ex parte order approving a wiretap. If the judge under this statute, if the judge determines on the basis of facts submitted by the applicant that, so they have to, the person submitting it, which would be the police or the prosecutor or whoever, they have to, it's determined on these three things. A, there is a probable cause for belief that an individual is committing, has committed, or is about to commit a particular offense enumerated in section 2516 of this chapter. B, that there is probable cause for belief that particular communications concerning that offense will be obtained through such interception. And C, normal investigative procedures have been tried and have failed or reasonably appear to be unlikely to succeed if tried or to be too dangerous. First, the district court appropriately denied the motions to suppress because the applications established probable cause. A reviewing court assesses the application on the totality of the circumstances and in a reasonable and common sense manner. In an application involving an informant, the totality of the circumstances analysis includes the veracity and basis of knowledge of persons supplying hearsay information, and the issuing judge must be reasonably assured that the informant was credible and the information reliable. A reviewing court affords great deference to the issuing judge's determination of the circumstances at the time of issuance. The district court properly found probable cause based on the initial wiretap application, and as well as the 12 related or supplemental wiretap applications. So that means there were 13 or 12 or 13 wiretap applications on Michael and this operation. Because the 12 subsequent applications rely on similar grounds to the first application, Clark focuses his challenge on that first application, contending that the issuing judge improperly credited information from informants and valued bare conclusory allegations with no requisite factual support. When was this, by the way? This is page 4. Okay, let me go up here and see what date. This was 2011. So this was what, 3 years before his Social Security application? After he had been caught with all these drugs and stuff, how could he even apply for Social Security? How could he get disability after all these drug charges and all this stuff? I don't even get it. It just shows you how much fraud. I mean, he's just a lying sack of nothing good. Anyway, the district court properly found probable cause based on the initial wiretap application as well as the 12 related or supplemental applications. Oh, I done read that part, sorry. Each of the informants had been cooperating for a year or more. The agent's affidavit details investigatory history with each informant, not just in the introductory sections for the informants, but also throughout the remainder of the affidavit. I want those affidavits. Crediting the information where appropriate while considering the limitations for each informant, the district court properly found that the informants provided sufficiently reliable information toward establishing probable cause. Clark also objects that the application provided no source of information for facts asserted and drew conclusions irreconcilable with the facts included within the four corners, but these contentions likewise lack merit. As to the source of information, the agent expressly states that he personally participated in the investigation and also included information provided by DEA and FBI agents and local police officers in Michigan and elsewhere. Oh, Tweety Bird had a whole lot of people ratting him out, it seems like. You think that's not going to happen here, too? As soon as all this stuff starts blowing, I told you it was going to end up being Bill Cosby about the women. Well, it's coming. I've got to tell you something else on that, too. They're coming. They just don't want to be on camera. They don't want to go on camera with their face, and their kids have to deal with it. Because that's what most of these women are mothers. Most of these women have children. And that's the biggest thing. They don't want their kids knowing what they went through. And I don't blame them. So this one I'm going to do hopefully tomorrow or Sunday. We'll get hers recorded. And we're going to do, she might even come on the show and just keep her camera off. So if we can get that done, that we'll be doing that this weekend. The affidavit recounts specific surveillance operations, interviews, and monitored telephone conversations. I want those tapes. I bet we can get them through the public records. I bet we can. Diggers, I hope you're already typing up the request. Where the application needs to show probable cause, not establish guilt, the source information provided stands as appropriate and sufficient. Likewise, Clark's argument concerning conclusions drawn in the agent's affidavit merits no relief. While the agent provided the specific investigative background noted above, the agent also described his own training and experience and asserted those to provide him with additional basis for drawing conclusions. Of course, such training and experience do not afford an officer carte blanche to speculate in any investigation, but instead the training and experience fold into the overall evaluation of probable cause as weighed by the issuing judge. The district court also properly denied the motion to suppress because the application met the necessity requirement. To demonstrate necessity, an application for a wiretap authorization must include a full and complete statement as to whether or not other investigative procedures have been tried and failed, or why they reasonably appear to be unlikely to succeed if tried or to be too dangerous. The applicant's burden is not a heavy one. To meet the requirement, investigators must give serious consideration to the non-wiretap techniques prior to applying for a wiretap. Wiretap is not resorted to in situations where traditional investigative techniques would suffice to expose the crime. However, applicants need not prove that every other conceivable method has been tried and failed. Here, the agent provided a thorough description of his consideration of other investigative techniques, including reporting limited successes where efforts to pursue those techniques had been attempted. To the applying assistant United States Attorney also affirmed that other investigative techniques had been attempted or would be unlikely to find success. As to necessity, Clark also contends that each renewal or related application results in an increasing burden for the government to show necessity. I'm not even going to read all that. Okay. B. Clark also argues that the district court erred in denying his motion to suppress evidence seized from his residence and vehicles, where the motion asserted that the search warrant affidavit filed properly to establish probable cause and officers could not have relied on the warrant in good faith. Reviewing the district court's ruling on a motion to suppress evidence from a search, we evaluate factual determinations under the clearly erroneous standard and conclusions of law under the de novo standard. The affidavit has some basic flaws, assuming without deciding that it lacks probable cause. Nevertheless, the good faith exception to the exclusionary rule applies here. The exclusionary rule does not bar evidence seized in reasonable good faith reliance on a search warrant subsequently determined to be invalid. A reviewing court, therefore, must determine whether the supporting affidavit was so lacking in indicia of probable cause as to render official belief in its existence entirely unreasonable. In 4 situations, the good faith exception does not apply. Number 1, where the affiant provided false information to the issuing judge and knew or should have known about the falsity. I'm always listening to this stuff, seeing how it applies in other cases and other stuff that's been going on here. I'm always thinking about that and trying to compare and see. Number 2, where the issuing magistrate wholly abandoned his judicial role. 3, where the supporting affidavit is devoid of indicia of probable cause. And 4, where the warrant is so factually deficient, that the executing officers cannot reasonably presume it to be valid. Well, that'd be awful embarrassing, wouldn't it? Clark argues that the first and the third Leon exceptions should apply in this manner. Well, of course he does. But neither carries the day. No evidence suggests that the affiant provided false information. So while the criminal history as presented appears unrelated and wholly tangential, the lack of falsity takes this case outside of the first exception. Okay. So I'm going to skip past all this. District Court appropriately denied the motion for mistrial, where the prosecutor solicited improper testimony at least once, but not flagrantly in the context of the entire trial, and strong evidence demonstrated Clark's guilt. At the end of the first day of trial, Clark stipulated to a prior felony conviction for the felon in possession counts. 2 days later, the prosecutor elicited improper testimony from a case agent concerning the specific crime. Question: does he have a felony conviction? Yes, ma'am. For what? Armed robbery. The court: just a moment. I thought there was a stipulation on this. I thought there was an agreement that the evidence would come in. May we approach? I don't think we need to. I understood, and correct me if I'm wrong, I understood that the defense for Mr. Clark was going to stipulate that there was, in fact, a felony conviction on his record. Is that correct, Mr. Steingold? That is correct. Then that ends the inquiry. At the time Clark entered his stipulation, the district court granted a motion to exclude mention of prior convictions related to Clark and Jackson. That must be why he must have got out of it. So he must have had a 50-year conviction or sentence, and 3 years later he was out and right back here in Kentucky. So the second incident, while still potentially problematic, does not implicate the same concerns. On the first day of trial, the district court ruled that as to reputation evidence, he would have to hear specific questions and specific objections, and thus could not make an in limine ruling in advance regarding all potential reputation testimony. A couple of weeks later, during the redirect examination of Kevin Youngblood, the prosecutor sought to delve into Clark's reputation for violence, and after an initial objection, the district court permitted the questioning to proceed. However, after the prosecutor asked about specific instances, Clark objected, and the district court upheld that objection. Later, the prosecutor asked Youngblood whether he had a contract on Clark's life. Youngblood responded that Clark had contracts on him and 2 other men, and Clark immediately objected. Counsel engaged in an extended argument that appeared to confuse the posture at the time, and the district court's prior rulings on reputation evidence and 404B evidence, and a prior Rule 609 stipulation between Jackson and the United States. The district court ultimately sorted out the confusion and upheld the objection. As part of the rationale, the district court indicated that the jury, which had been out for lunch for over an hour, would not remember the question or the answer. On that basis, the district court declined to give a curative instruction. However, it permitted Clark an opportunity to propose an instruction to be given later. By written motion incorporating all instances of alleged prosecutorial misconduct, Clark ultimately moved for mistrial, but the district court denied the motion, finding as relevant to the second instance that the instance did not rise to the level of prosecutorial misconduct. Importantly, the incidents, even if both improper, were not flagrant. To assess flagrancy, the court examines whether the statements intended to mislead the jury and prejudice the defendant, whether the statements were isolated or extensive. 3, whether the statements were deliberately placed before the jury, and the overall strength of the evidence against the defendant. The incidents 2 out of a multiple week, many witness trial were isolated, not extensive. Regarding the first incident, the one definitely and obviously improper, the district court emphasized that the jury had already heard that Clark had a prior robbery conviction because that allegation appeared in the indictment, which had been read to the jury. Clark now contends the district court's rationale to be erroneous because the district court also instructed the jury that the indictment should not be considered as evidence, and juries are presumed to follow instructions. Of course, This same logic defeats Clark's current argument because after all proof had been taken, the district court gave the jury an instruction that Clark had stipulated to a prior felony, and any information about that felony otherwise does not relate to the instant matter. The parties have stipulated, as I indicated, and agreed that Michael Clark had a prior felony conviction. This evidence is admitted only for the purpose of establishing the element of the charged offense which requires proof of a prior felony conviction. It is not to be considered as evidence that Clark has a propensity to commit crimes or for any other purpose. That instruction, presumed to be followed, removed prejudice. Clark argued the prosecutor's efforts to be deliberate, but the solicitation of improper testimony here was more careless and inattentive than deliberate, though nonetheless serious. A key factor, the evidence against Clark stands as quite strong. For example, multiple witnesses, including co-defendants, testified that Clark supervised and participated in a multi-person drug network that brought marijuana and cocaine into Detroit using tractor trailers, distributed the drugs, and collected the money. The wiretaps turned up conversations specifically documenting Clark's activities with and in this organization. Officers intercepted one shipment of over 1,000 pounds of marijuana and overheard Clark in an intercepted call just after the interception, lamenting that all his weed had been in the truck. We find no basis for reversal. The prosecutor's careless and inattentive solicitation of improper testimony does not rise to the level of flagrancy, and in light of the strong evidence against Clark, reversal is not appropriate. The district court properly denied the motion for mistrial based on alleged prosecutorial misconduct. Clark asserts that as to his continual criminal enterprise conviction, CCE, the evidence failed sufficiently to establish supervision of 5 or more criminally involved persons. We review de novo the sufficiency of the evidence to sustain a conviction. Here, sufficient evidence supported Clark's CCE conviction. The following elements constitute the offense of CCE. Number 1, that the defendant committed a felony violation of federal narcotics laws. Number 2, that the violation was part of a continuing series of 3 or more drug offenses committed by the defendant. Number 3, that the defendant committed the series of offenses in concert with 5 or more persons. Number 4, that the defendant acted as an organizer, supervisor, or manager with regard to these 5 or more persons. And 5, that the defendant obtained substantial income and resources from this series of violations. Clark challenges only whether sufficient evidence existed as to the 4th element, organization, management, and supervision of 5 or more criminal participants. Specifically, he alleges that the evidence demonstrated supervision of only 3 participants: Charles Gadsden, Cornell Lewis, and James Jackson. Contrary to Clark's protests, the evidence sufficiently established organization, management, or supervision of 5 or more participants. Clark characterizes participants other than Gadsden, Lewis, and Jackson to be simply buyers or sellers, distant sources of supply, or innocent dupes, all with real indicia of control by Clark. In finding a defendant guilty of CCE, the jury need not unanimously agree on the identities of the 5 particular persons, nor need the 5 persons be named in the indictment or bill of particulars. So this is really important to understand if they were going to charge anybody with this down this way. These are federal. This is federal, so it doesn't really, which I'm no lawyer, I'm just guessing. But if it's federal, I'm guessing that the same laws apply in Michigan as apply in Kentucky too, and any other state. A person can be found to be under the defendant's organization or supervision because she knew about the drug operation, took orders directly from the defendant, and helped in the drug business. A broker or courier under the defendant's supervision, someone who stores drugs for the defendant, or one who collects or launders drug proceeds is also within the ambit of the statute. Standing alone, a purchase of drugs from an alleged organizer does not establish the supervisor relationship. Likewise, simply fronting drugs does not demonstrate a supervisor relationship. Innocent participants also do not count in the supervisor calculus. A national trier of fact could have found beyond a reasonable doubt that Clark supervised 5 or more persons. Melvin Reed, Cornell Lewis, and Kevin Youngblood all testified that Clark supervised at least 5 participants in the drug organization. According to Reed's testimony, he collected money for Clark, and he sold whichever type of drug, cocaine or marijuana, that Clark and Lewis specified. Clark concedes Lewis's role, and consistent with that concession, Lewis testified that he sold drugs, including cocaine and marijuana, for Clark. Youngblood also testified that he sold cocaine and marijuana for Clark, and that people from Clark's car washes would help load marijuana. I don't think this is the right Michael Clark. I started wondering about that just a little bit ago. I don't think this is him. I think this is a different Michael Clark. Witnesses further testified about the involvement of an additional party, Gerald Allen, who delivered drugs and collected money for Clark. Last night I saw something that somebody had shared that about him, but it was a Michael B. Clark. See, at least this one had the name right, Michael Anthony Clark. The one that I saw last night said that he was like a predator with sexual crimes. Well, I had saw that last year too, being circulated, and it wasn't him. It was a different one. So I think this is a different one too, because I don't think he has any car washes. Next, Clark argues that entry of judgment against him for both CCE and underlying drug conspiracy charges. But I want to read it. I'm going to finish reading it, you all. Well, maybe we won't, because I had something else. We wanted to listen to that interview. Clark's felon in possession relied on a 1992. Yeah, I don't think this is going to be the right Michael Clark, y'all. I think that's going to be a great big old egg on my face on that one. That's okay, though. No worries. I think it's the wrong Michael Clark. But at least we figured it out, right? Before we got too far into it. It's just about halfway through it. But, it's all right. Here, let me pull this other up, and we're going to finish this. We're going to listen to the Jennifer Hill interview with Matt Easter. I'm glad I did read that, though, because it gives us a good understanding of the laws and the way that those wiretaps work and stuff like that. So, it gives us a little interesting information. Anyway. All right.
Today's date is February 14th, 2022. Praise myself, Detective Easter, Detective Blevins with the Kentucky Attorney General's Office. We're with him.
Can you hear it?
What's your date of birth again? Can you tell me about your interaction with Ben Fields?
Yeah, he was. I got on house arrest. I can't remember the dates. I've been on it 3 times. Okay, well, the first time I was on it, let's see, it was in December when he had me on the display. I figured that out because my house burned down at the same time.
Display?
Yeah.
What's that mean?
It's a fake house arrest bracelet. It doesn't work. It has no coordinates to it.
Why would you be on display?
Because he wasn't making me pay, and then he was letting me go everywhere I wanted to, and then when I was on the regular one, and Patty, the one that's above him, told him that to revoke me because I was leaving all the time. She didn't know he was giving me permission to leave all the time. Well, and my fiance, he was my fiance at the time. Now he's my husband. He can verify because he took me everywhere. He knew I never did call or anything because I wasn't having to pay, like I said, because me and him had kind of like I wouldn't call it wasn't a sexual relationship because we didn't never have sex, but it was talked about a lot. You know what I mean? He made a lot of comments and stuff about it.
So let's start back at the beginning. Do you know Ben Fields prior to your arrest?
No.
Okay. So you got arrested for what?
I've been arrested a couple times.
Well, let's take the first time you met Ben. At the very beginning.
When I first met him, he was a guard at the jail, but he never did speak to me. I never did speak to him. But now when I got on house arrest, he was just real nice and he was real friendly on the phone and stuff.
So when you get on house arrest, you get arrested. To get out of jail, you can go on house arrest.
Yes.
What do they tell you? Do they tell you to go?
Now, just to catch you all up and explain to everybody who doesn't know, Jennifer Hill, the girl who's in this interview, is no longer with us. She passed away from a very suspicious overdose. I'm not sure what the date was that she died, but it was before Ben Fields was sentenced and took his guilty plea, because originally he was charged with Sabrina and Jennifer Hill, but when she died from the OD, that stuff was dropped against him. It was completely dropped. And there have been accusations made that Mickey Steins told one of these women that they might get the money. This lawsuit might go through. It might be successful, but that he allegedly told them that they will never live to spend a dime of it. And that allegedly came from Mickey Steins, not Ben Fields. So I think that's very important to share. And that was told to me by the person that says Mickey told them. So
To the courthouse? What? How do you all meet Ben?
We go upstairs by ourselves.
Who told you to do that?
And remember how, this is my big thing. How is he talking to these women? Notice how he talks to them. And then when we listen to Ben's interview, you guys are going to hear a drastic difference. This guy takes everything these women says, and you'll notice, he creates the narrative that it was these women. It wasn't Ben. The narrative that he creates by the way that he asks the questions. He's the one who constructs these questions. So by the way that he asks his questions and what he does with their response. So make sure you pay attention to all of this stuff. And tell me after we get done if you don't see it the same way that I do. Or if you don't see it the same way that I do.
The judge.
The judge.
Yeah.
Tells you to go get up with Ben.
That's your bond, yeah.
So
And then
then you go get up with Ben. And then what happens?
you pay like $100 and some dollars. My mother-in-law, she paid it. And they put you on an ankle monitor, and you're to go straight home, and you're not to leave home unless you call and let him know, and he gives you permission, or Patty gives you permission, unless you work or something like that. Well, I never worked, but I stayed on the road, and you're not supposed to get high whenever you're on probate, whenever you're on the house arrest bracelet, but I was constantly getting high because I was allowed to go anywhere I wanted to because he was letting me. But he was friendly, just a friend at first. So he was all friendly. And like, he just kind of started getting.
Did you hear what she said? She said he let her go wherever she wanted to. Like, he wasn't giving her no hard time. He was letting her do whatever she wanted to. And she said, I was staying high all the time because I was allowed to do whatever I wanted. So, I mean, of course, she's going to drop dirty and stuff, you know. I mean, Ben Fields put these women in such a, well, it wasn't just him. They all put them in a horrible, horrible cycle of, this is sex trafficking is what this is.
He was pushing himself more into, like, you know what I mean? He was like,
Well, don't you need to explain to me?
He would get a little more friendly or every conversation.
And how by friendly is, I say yes sir, yes ma'am. That's friendly to me. What do you mean by friendly?
No, he would call me honey and sweetie and baby doll and stuff like that. And
so you get out. He's gave you a monitor. Is it turned on that first time that he gives you one?
Yeah.
Because you pay it, like you said, your mother-in-law pays it, right? Okay. So you've got it paid. And then, are you supposed to be checking in with him?
Check in every Wednesday.
Every Wednesday.
They check in.
And is that when he's starting to be more friendly?
Yes.
Okay.
In person. But he was also like messaging me and stuff. Like that's how you would get a hold of him. You would text his phone or something like that. Well, I didn't have to text his phone. He added me on Messenger, and then he added me on Snapchat. Snapchat is where it kind of started at. He started kind of telling me that I was pretty and stuff like that. And I'm not gonna lie. I told him he looked good in a uniform, and he was like, "Well, it's just a uniform." And I was like, "No, you look good anyway." And then that kind of escalated. It escalated from there. And one time I walked into the courthouse to pay it, and I told him I was like, I'm having problems, with paying it this week. He's like, just don't worry about it. And then I started like going. I told him I was going to go here, and he just told me he just didn't care. Where I went, he would let me go wherever I wanted to. Was I going to get dope? Yeah, because he didn't care. You know what I'm saying? And I was a drug addict at the time. I've been 8 months clean now, but
Good. Hope you keep it up.
I'm trying. I'm in drug court. I have to. But
You have to, because for you,
right.
drug court secondary. I get what you're saying. Yeah, keep up for you.
Yeah, it's been a struggle because I just lost my daddy, but.
You can tell neither one of those men have any experience in substance abuse. Keep it up, man. Keep it up. Yeah, you got to do it for you. Drug court secondary. I mean, you can always tell when somebody ain't got a lick of experience in it and all they're doing is repeating stuff that they hear other people say. That was one of the big reasons why I wanted to work with law enforcement, was I wanted to be able to train police officers in how to deal with addicts and addiction. Little pipe dream I had at the time.
So y'all are having these messages on Snapchat and Facebook, which is mostly
Snapchat, because you can't keep the messages; they disappear as soon as you open it.
What are some of the messages on Snapchat?
That's when he made the comment that he would like to bend me over and fuck me over the desk. And when I went, and I kind of put a smiley face back to him on it. So when I went in that Wednesday to make it look like I was paying, that's when he told me Patty wanted to revoke me, but he wasn't going to revoke me because he wasn't going to put me in jail, even though that was his order. He put a display on my leg and told me if I ever got pulled over to call him.
And see that right there, he just set up by him telling her that Patty wants to revoke you, but I talked her out of it. I'm going to be your get out of jail free card. So here, I'm going to give you this bracelet. And so now he has indebted himself to her, or the other way around. You know what I mean? So now she owes him something. You know, now he's done her a solid. So now she owes him. That's part of the grooming process.
Why to call?
I don't know. I guess so he could make it look good or something, because what was on my leg didn't. There's no coordinates because it never worked.
If when your smiley face, did you have a relationship with him, like you wanted a relationship, or was this because of the situation?
Because of the situation.
How did you?
I flirted back.
Have you ever heard of any other girls that that you didn't have to pay the bracelet or could do what you want to? And this, if you flirted with him or had a sexual relationship with him?
No, I really didn't talk about it to nobody because to be honest, I didn't want somebody else to try to do it. And then him, how can I say that? Like,
Him get caught.
too many try to do it, and then he couldn't do that because he needed the money or something like that. You know what I mean?
So you don't know any other girls that this happened to?
No, I just know of that girl.
Do you know her? Have you ever talked to her?
No, I just heard about it.
Where'd you hear about it?
Actually, I was talking about it in drug court, and because he had walked by one day, and I called him a son of a bitch.
Why would
Not
you
to
do
his
that?
face, but I said that son of a bitch.
Why would you
Because
upset at him?
he took me to jail. I called him and told him, I said, my house arrest bracelet is dead. This last time I was on it. I was just on it for a short period of time. But it did work, and I was paying. But he hadn't really been talking. We weren't really talking that much about anything like that. It was more business this time. But I told him, I said, Ben, he let me out that day. I went and paid my house arrest payment. And I went and I told him I was going to go to my mom's house and see my kids and stay all night there. And I said, me and my husband are arguing, so I don't want to go home. And he was like, well, you go wherever you need to. And me and my mom kind of got into it, so I didn't go there either. I went and seen my dad. And then I went and visited one of my friends. Well, my ankle bracelet died. And so I called him and I said, Ben, my bracelet died. And he was like, well, look, you don't want to get in trouble for absconding or escape. So I said, well, what do I do? Come get me. And I went back to my mom's, and he was like, I said, I didn't want my mom. My mom could have sent me to the jail, but he offered, I was like, will you come get me? I was like, you can come get me and take me home if you want to. Or if you got to take me to jail, come. He was like, well, I can do that. I didn't know which one he meant. But when he come got me, he was like, he told me and my mom, my mom was right there. He said, Christy, he said, I'll have to take her to jail because where her house arrest bracelet died, it's going to look like she tried to escape. So that clears her name on that. I'm going to take her to the jail, but I'll go straight back and get her in the morning. I left.
You know what? I said that was Jennifer Hill. I don't think that's Jennifer Hill. She just said her mommy's name on there. Said her mommy, she said he looked at her and said, Christy, I have to take her to jail. I know who that is. I know exactly who this is. This is not Jennifer Hill's testimony. Oh, interesting. If you guys remember, those of you who have been following this case, at the very beginning of this, we heard that there were 3 women that were involved in this lawsuit. But only 2 of them were named in the lawsuit. And I never heard another word about the third girl. We see mention of a third girl in the deposition. In one of the depositions, I'm pretty sure is where it's at. Or it might also be in the discovery for Ben. It might have been in Ben's discovery, but I don't think this is Jennifer. Now, we do have Jennifer's. I've got another one that must be Jennifer's. It doesn't say, excuse me, it doesn't say they've redacted the names out. So I was assuming that this was Jennifer Hill, but it's not. I think this is, well, she just said her mommy's name. He said Christy, and I know who the third girl was. Just through my own investigation, I found out who the third girl was, and her mommy's name is Christy. So I think this is the third one, the other girl. I don't think this is Jennifer's, but still, it's still one of the interviews in Ben's discovery.
My bag's in his car. He kept them. My phone, he kept it for me. He ended up taking it to my mom. Well, he's supposed to take it to my mom. A couple of days went by. He never did, but he turned it in at the jail. Days after. You're not even supposed to keep your property like that. You know what I mean?
So so you're saying he arrested you because your bracelet died?
Well, I told him that it had died, and I told him to come get me. And he said, well, I'm going to take you to the jail, but I'll be straight back to get you in the morning.
Why would he take you to jail just because couldn't he give you another bracelet?
I don't know. He just told me he would have to take me to the jail. And I was sitting in the back seat, and he told me to lean up front, and he opened that window right here. And when he did, he kissed me, kind of like aggressive like. And when I kind of scooted back from him, because like I said, we hadn't done nothing like that this time while I was on house arrest, because I wasn't on drugs anymore. And I was trying to be a better person.
So we'll go back to right there. So, and you said before, so the first time you got out, you're still on drugs.
Yeah.
And that's, you all had the flirtatious. Is that when the Snapchat messages took place?
Yes.
And that you said you flirted back with him?
Yes.
So then you get in jail again?
Yes. Actually, my bracelet and those charges went away. I don't know whatever. I never went to jail after my bracelet burned up in my house. I never went back to jail. This was over something else. Way later when I went to jail. I don't know. I never went to jail after that.
You're confusing me, which is not hard. But, so, you get in jail, you get out, you're flirtatious, that's the Snapchat.
The reason why they're confusing him is because he did not sit down and have a prepared set of questions to ask her. He's not, you can tell, he ain't no he's no SMECS assault specialist. He's not trained in interviewing a victim of SMECS trafficking. He don't know what the hell he's talking about. And the kinds of, he's not even asking her questions to where you can follow her accusations in a, in any manner. He's not doing it chronologically. He's not doing it in any organized manner. So this interview is kind of like all over the place. And you can't tell me that they're not doing that intentionally. Because if he can make it as confusing as possible, then how the hell are the grand jurors or the jurors supposed to follow it? I mean, I'm picking up what they're laying down every time they drop it.
Error, let's say. You get popped again for another criminal charge. What charge was that, the second one?
Methamphetamine.
Possession?
Yeah.
Where at?
Whitesburg.
Okay. So now you got in again, you've got to get out again.
Right, but see now, the first time when I got out, when it was flirtatious and all that, that's when he kissed me in the chambers.
In the judge's chambers.
Yeah, well, in that hallway right there to go to the chambers.
What were you doing there?
I was there. Everybody goes there at 4:30 to pay their house arrest. He told me to come up there about 5, so it would look like he was checking my bracelet. Well, that's when I had the display on my leg. But I didn't have to pay him anything, and he didn't check nothing because that's when I said Patty told him to revoke me. But he put that fake one on my leg, and he said it didn't have nothing, no kind of charge or nothing. It didn't work. And he said, if you ever get pulled over, just call me and let me know, and I'll figure it out.
Okay.
Well, then,
Not to interrupt you, but I want to get back in line here, so I get chronological. You get out. The first bracelet he gives you is real. It's working.
Yeah.
And then as your relationship builds,
Let me tell you something else that I've noticed he's done, and he did it to Sabrina too. They get talking about something and he'll interrupt them. Like they'll be talking about something that's big, something that is important, and they'll be making a point, and he'll interrupt them and start talking about something that doesn't matter, something that doesn't mean nothing. But he will stop the women and interrupt them at a point where it does mean something. And so then whenever he gets done talking about whatever BS he threw in there, the girls done forgot what point she was making. I noticed that he's done that a lot too. That's what I said. What he did to these women, to this case, should be criminal. He should get in trouble for what he did in this case. And I think more people should have to be held accountable for either their incompetence or their misconduct, because there are real people on the other end of these actions that are either going to go to prison or they're going to get away with their crimes.
that's when you come back and he gives you
the display, because she told him to revoke me because he was letting me stay gone all the time. She didn't know he was letting me. He wasn't telling her he was letting me.
So now you're at the courthouse. You said he kisses you. Was that a mutual kiss between two people?
No. He
Explain that to me.
After he put that on my leg and I stood up to leave, he kind of grabbed me by my shoulders and kind of like, he didn't like hurt me, but he just kind of like pushed me up against the wall, and he started kissing me, and he was holding me up by my hind end.
Maybe this is
Did you tell him to
Jennifer.
quit, or did you?
No,
What did you say to him? Did you say anything?
no, I didn't say nothing. I was kind of embarrassed, but
He said, did you tell him to quit? What was she supposed to say? Stop? She was supposed, because she didn't say quit? What the hell is wrong with him? He knows what would happen if she said, stop, don't do that. And this might be Jennifer. Maybe Jennifer's mommy's name was Christy. I don't know. It doesn't say who it is, so honestly, I don't know who it is. But I remember this interview because she says that he picks her up by her butt and puts her up against there and starts kissing her so hard she feels like he's trying to eat her face. I think she says that here in just a second.
it's kind of like, I went along with it because what he had just done.
Okay, then what happened?
Well, then after I left, then we talked. Like I said, it was like on Snapchat and stuff, and we would talk dirty back and forth. But that's when, shortly after that, that's when my house burnt down and my house bracelet was in it, and it all just went away after that. Nothing was done.
When you were prior to the kiss, did you talk sexual stuff to him from like?
Can you believe
your perspective
him?
to him? Did you say sexual stuff to him?
Yeah.
Like what?
He just asked me how I liked it, and I would tell him. You know what I'm saying? And I would I would send like hearts and smiley faces, and then I would send wink faces. You know what I'm saying? I went along.
Now, did you hear what she said? She said he asked her, "How do you like it?" And she responded and told him. I've been in that position where I was talking to somebody. Here I am trying to get my foot in the door about a job, and all dude wants to do is send me his pecker and talk dirty. And that was not what I wanted to talk to him about. But I had to laugh it off. I had to, like, kind of talk right back to him. Now, I never sent him nothing to me, but I had to kind of talk right back to him so he didn't get mad at me. I was trying to get my foot in the door. I was trying to get him to help me get my foot in the door. And I was afraid if I did get upset and say something to him about his pecker picks, that he wouldn't talk to me again and I'd never get my foot in the door. That's the same thing. It ain't no different. It's no different other than, these girls had jail over their heads. These men had made a way, because you had Bert Sloan, who won the jailer position, and Bert was joined at the hip with Judge Mullins at all times. You didn't see one without the other if Judge Mullins was downstairs in that basement. I mean, and they were constantly going to these rehab things together, these big treatment speeches, or, what do they call them? Conferences or whatever. They were always going to stuff like that together. Whenever Bert Sloan became the jailer, Judge Mullins saw an opportunity to take over that jail. And he did. He absolutely did. And Bert Sloan let him. Bert Sloan absolutely let him. And now wants to sit there and say, well, I never saw the judge ever do anything wrong. Never, ever, ever did I see the judge ever do anything bad. I don't believe you, buddy.
Oh, good idea. I'm going to lie about that.
That's fine. Like I said, don't be embarrassed about it.
She didn't have a damn thing to be embarrassed about. These girls didn't do anything wrong in this situation. Now, people can say whatever they want to, but if you are if you were an inmate in a jail, if you were on house arrest, there was no consent to it. There is no mutual kissing. They were not in a position for any of that to be consensual, for any of it to be mutual. And if this is our state's best, then we are really in trouble. I mean, the only office that I would really consider running for is the governor of Kentucky, because I know that I could do better than Andy freaking Beshear. The shit that he has allowed to continue in this state, because he is, I don't know, you tell me, somebody tell me. But I can tell you that if I was to ever win an election like that, honey, we would completely revolutionize the state of Kentucky. Change it. I mean, I would clean house from the top absolutely to the lowest bottom. I'd make history.
So now he's kissed you. He's put a dummy bracelet on you, or the display bracelet. Then what happens? How does stuff continue?
He told me that. I said, well, do I got to pay anything? And he said, no, we'll work something out. And he winked at me. And then it kind of got a little bit to where I felt like we were in like a kind of like a deep friendship, because when he'd done this wreck up here where that little girl got killed out on the bypass 2 years ago, he messaged me and he was like, I just worked this wreck and it was horrible. And he was like telling me about how bad it was, because they said that they didn't know that little girl was in there until they was cleaning everything up and they found her. And then we kind of developed like a deep friendship, you know what I mean? But after that,
I think it's funny that all of these girls, not funny, but all of these girls thought that Ben was their best friend. He had manipulated and weaseled his way into their lives to where they thought that he was like their best friend. He's telling them where all the good dope is. He's telling them who the rats are and who to stay away from. Letting them do whatever they want to do. Like they had turned that jail and the house arrest program into their own little honeypot brothel. But no investigation. No investigation needed.
I went to jail, and then that's when I got house arrest again. But that time when I got house arrest, everything was strictly business.
Okay.
Until he locked me up and didn't come back and get me the next morning after I pushed him away kind of and didn't kiss him. He didn't come back and get me the next morning. Although my bond was house arrest and surety bond, he would not come get me and give me house arrest. Patty said yes, who was over top of him, but he wouldn't give it to me. And my mom, she told Mickey, she said, I have to leave in this town, but I know why he won't give it to her. Because I told her about it.
So,
Sorry, let me cut this off.
Yep.
we got a Snapchat time frame, and then you get rearrested. You got to meet back with him again. That's when he puts the dummy bracelet on you and kisses you. You go through another period of time. You're talking to him. You get rearrested, and that's the time he kisses you in the cruiser.
Yes.
What is that charge for?
That was just where my house arrest bracelet had died. It was revoked. When I got up there, they revoked my bond, but then they reset it because they seen I didn't escape. They told the judge what happened, that I turned myself in. See, he took me to jail, but they done it as I was turning myself in.
So Patty, but that bracelet, the display bracelet, doesn't have. It's not working. So
No.
how do they know that it's dead?
Like that's all this guy seems to ask questions about, or this bracelet. And can you charge it? And, I mean, he's asking the stupidest questions that have absolutely nothing to do with what they are even investigating him for. Nothing. It's kind of like they charged him with tampering with an inmate's monitoring device. Is that what it was called? I think it was. Does it call him an inmate in the charge? That's very interesting. Crystal, if there's some way that somebody can Google that real fast and look and see if the charge where it says tampering with an inmate, that's what I'm remembering. Is it inmate? Tampering with an inmate's monitoring device is one of his charges. If somebody can look that up for me real fast. Then that would label her as an inmate. But it was Sabrina. It wasn't this one. But still, it's the same thing. Still the same thing, no matter which girl it was. But it would have to be Sabrina, because Sabrina's the one that anything stuck. But if they had done a proper investigation and had investigated the judge, Daniel Dotson, Michael Clark, and everybody else that needed to be investigated, police, Whitesburg PD's finest, there needed to be a bigger investigation into sex trafficking, and our own Attorney General's office, who has a sex trafficking task force, decided to send this fool to interview these women. This isn't just any sex trafficking, potential sex trafficking investigation. This is an organized crime syndicate that involves county government that could go all the way up to state. And looking at the feds and the pattern that we've seen from them, whoever the ones that are working this office in eastern Kentucky, it might even spread to them. I mean, somebody had to approve Scott Blair's case. Somebody had to approve those charges and the recommendation, the sentencing recommendation. Somebody had to work with Ned Pillersdorf on those negotiations. I wonder who it was. And what connections do they have to Letcher County and Judge Mullins? Because this is ridiculous. This should be criminal.
I mean, she thought I was locked up because she told him to revoke me. He was the only one that knew anything, and she don't tell nobody, like the judge or nobody. That's up to him to do.
So you're saying that Patty thinks that when he takes that original bracelet off and gives you the display, Patty thinks that you're still on the monitoring.
No, she thought I was going to jail because she told him to revoke my house arrest bracelet.
But he didn't.
No.
So then later on, they find out all this, right?
I don't know if they ever found it or not. Like I said, I never went to jail over it.
But why did you get arrested though for your display being dead when nobody knows it but you and him?
No, my display wouldn't what was dead. Okay, after my display, like I said, when I had the display on, it burned up in my house. You could take it on and off. It burned up in my house. Well, after I told him it burned up in there and everything, I never went back to jail. They knew I was off house arrest and I wasn't on the bracelet, but I never went back to jail, period.
You just didn't volunteer to go say, hey, put me another bracelet on.
No, I didn't need one, they said. I mean, he told me everything was okay.
He told you that?
Yeah.
Okay.
And then after that, then I got charged with, it was an old charge for.
But you know, that's something that he should have done as part of his investigation, would be to go pull up those charges and that part of her house arrest and her drug court and pull the records and see why she didn't get put back on there. Something had to be entered on the tail end of that to where they either closed her case, however, dismissed the charges, or something. I'm going to give you guys a really, really big update as soon as this is over. We got another big, huge interview that's going to be coming tomorrow or Sunday.
Possession of methamphetamine. But the one charge that I had with that charge, what they found in the car wasn't meth. It was Epsom salt. And they thought it was meth, but they sent it off and finally it come back and all that stuff. But they did get me with what was in my purse. But that's what pretty much I'm in drug court over now. Because when I went to jail, when he took me to jail, and they told me, they said, well, we're going to revoke your bond, but we'll reinstate it in the morning. He's going to come back down here and get you in the morning and put you back on house arrest. So they don't get you for escape, because, I told him to take me to jail, so they looked at it like I was turning myself in, because my bracelet died, so I wouldn't turn myself in. Like I had just been past curfew. Well.
But you didn't have a bracelet?
No, my bracelet was on then. It had just died. This was this time. where I told you to just been strictly business. That was this time.
That's the kiss in the car.
Yes.
Okay.
As he was taking me to.
He still can't follow her. You can tell plainly that he just pretended just then. Oh, okay. He just pretended to understand what she was saying. He obviously could not follow anything that she said. Like, I mean, I just can't. I cannot listen to this without getting so upset that this was allowed. You know, somebody else from that attorney general's office had to listen to these interviews, and they thought this was perfectly fine. Nobody saw anything. No, because this is exactly what they wanted to happen. That's right, trial junkie. He has an agenda. And the whole damn attorney general's office knew what that agenda was. Nobody can tell me that they didn't. I won't believe it. Even if you do, I ain't gonna believe it. I think y'all full of shit.
Jail for my bracelet dying. That's when he kissed me in the car and I backed up. And when I backed up, he took me on to the jailhouse and he said, I'll be back to get you in the morning. But I knew right then that he wouldn't.
Did you say anything to him about the kiss?
No.
How did he tell you just, I mean, if somebody's in the back, I can't obviously kiss them. How did
He
that
just
happen?
told me to lean up there. I thought he was going to tell me something at first. But he wrapped his arm around.
Now, he was charged with tampering with a prisoner's monitoring device. Now, he wasn't convicted of Jennifer Hill, but he did plead guilty to Sabrina Adkins, and he pled guilty to this charge, this charge right here. So if he was guilty of tampering with a prisoner's monitoring device, then how come her being a prisoner did not trigger the PREA laws? How come, if they're going to charge her with tampering with a prisoner's monitoring device, charge him, and he pled guilty to it, then how does that not make her a prisoner? How come he's not being charged with PREA laws? How come that didn't trigger PREA? And it probably would have turned it into a it would have turned it in. I'm not a lawyer, so I don't know. So I won't say something if I don't know it. But I think that's outrageous. You can't have it both ways. And I'm pretty sure that they said that the PREA didn't apply here because they weren't actually in the jail. They were on house arrest. So they weren't actual prisoners. Well, how come he can plead guilty to tampering with a prisoner's monitoring device? They're calling her a prisoner for that, but she's not a prisoner to trigger PREA. So now, this can even go to a trial, to a jury, for a jury to decide if it was consensual or not. How's that not a double standard? Like, I don't see how that goes through. Can anybody tell me? Can anybody tell me how she can be a prisoner for this charge, for him to plead guilty to this charge, but she's not a prisoner for PREA to apply? Can anybody give me that answer? Anybody with a legal background that can answer that for me?
I mean, then just started like, he's fucking bad at it too. I mean, I don't know how to explain it, but he was like all over my face, and anybody would have backed up. His wife probably would have backed up. I mean, I don't know if he was like trying to kiss me or if he was hungry. I told him that too. I was like, what are you doing? And I backed up, and after I backed up, he took me to the jail, and that's when I stayed in there for 3 months.
Now, this was when she said he kissed her so hard she thought he was hungry. I said trying to eat her face, but there you go. She said he was so aggressive. And she said even if he had kissed his wife that way, she would have even backed up. Like, to me, that tells me that he was really being forceful with her. And she even says somewhere that it didn't feel good, which I think, to me, I perceived that as it hurt. It hurt. I've been kissed hard and it hurts. It doesn't feel good. And I can just see him. How is this not?
And then they let me out on drug court, which is what I'm on now.
Okay.
Drug
See if
court.
I can get this straight here.
Again.
We get in trouble. We get out. You get it hooked up. You all start having sexual messages, Snapchat and Facebook. You meet him to pay your thing. He ends up giving you a display bracelet. Y'all continue your relationship of flirtatious. Your bracelet gets burned up.
You continue a relationship of flirtatiousness. Like, this dude is really, really trying hard. And I don't know how anybody can listen to this and not, like, are you joking? I get so mad listening to this, man.
You get in trouble again. They give you a real bracelet again. That is monitored. It dies. So it looks like you've escaped or not doing what you're supposed to be doing. So you're going to turn yourself in. How do you know why didn't you just stay hid? Or you knew it was dead, you needed to do something?
I knew I was going to get in trouble.
So you might as well did you contact the sheriff's office or the court? Did you contact Ben or somebody else?
Yes, and my mom contacted me.
And they said, come turn yourself in because your bracelet's dead. Before you could do that, Ben shows up at your house, puts you in a car saying, I'll take you down there. I'll get you out in the morning.
He asked me where I was, and I said, the whole day while my bracelet, like when it died, from then till I turned myself in, he knew everywhere I was at. And I told him, I said, will you just come get me and just take me down and let me turn myself in, so they don't think I've escaped. And he said, yeah. And he come to my mom's, which is across from Taco Bell.
But you were going to go to jail anyways. But he ends up getting up with you, so now you're in a car with your stuff. He tells you to come up through the screen where it slides. He then kisses you, and then you go on to jail 3 months later. Is that the end of your all's relationship?
Yeah.
Is this a police car or is he in his personal vehicle?
It's a police car.
Is he in
Relationship.
uniform?
Yeah.
Uh,
He's always in uniform.
I'm going to go back and ask again. I think I did. Did y'all ever have sexual intercourse?
No.
Any kind of oral sex?
No.
Did he, other than kissing you at the courthouse?
He's rubbed on me like that day when he kissed me up against the wall. He had his hands all over my front and my back.
Okay. With obviously, was that the same day as the kiss or just different times?
Same day.
So you had 2 times that were physical contact, kissing, 2 times kissing, and then the same day at the courthouse when he was putting the display on. What parts of your body did he touch? Your leg, your head, your elbow?
She said my front.
He ran his leg up my leg and then up to my private part, and then he had my honey. He was holding, like, both his hands were on each one of my ass cheeks, like he was had me lifted up, kissing me, lifted me up completely, kissing me.
Did you tell him no or
no?
Don't do this.
No.
Did you touch him?
No.
In a sexual way?
No.
Do you remember when those times were, like the meeting at the courthouse? Do you remember when that was?
It was about June when we met at the courthouse. It was in June of 2020. And then this time when he kissed me, it was August the 5th of 2021.
August the 5th, 21.
Yep.
And that's the cruiser kiss.
He drives one of the older ones, like the Crown Vics.
Have you had any communication with him since your arrest, that last time you spent the time in jail? Do you have any of those messages on your phone?
No.
Do you still have them on your Facebook account?
Yes.
Can you get in your Facebook account?
I've done a Google recovery, and it's supposed to let me know. It takes it a couple days, I guess, to do it, to prove it's you, to verify it's you.
Was that when he told you that he would, and I apologize, obviously I have to use the same words, so you'll know what I'm talking about, but when he told you that he would bend you over, is that the worst he said to you? Do you remember any more messages?
He would just talk about oral sex all the time, and he would talk about how hard he liked it. It was preferably the same.
Would you have had a relationship with him if it wasn't for that position of you knowing, or I wouldn't say relationship, you wouldn't have been in contact with him if you wouldn't have met him if you'd have saw him at Walmart, or
No.
you didn't know him prior to that?
Right.
Do you have his phone number? Do you know it? Did he ever ask and say, hey, when are we going to hook up and have sex or anything like that?
He never asked when. He would just talk about it all the time about us doing it.
What do you think the reason that he gave you the display for and let you go wherever and do all that? Why did he do that for you?
Because I was talking dirty back to him. I was doing it with him, you know what I mean?
If you would have not talked to him dirty, would he have done that?
No.
Now, I don't think this is Jennifer. Like I said, whenever she said that she went down and that Mickey told, or that her mom then went and told Mickey, I know who this is, and this is not Jennifer. I was wrong 6 months ago, or whenever it was that we first listened to these. I assumed then that this was Jennifer Hill. This ain't Jennifer Hill. I know exactly who this is, and I'm just now realizing it. I had it wrong the whole time. It's the third girl. Yep, she played the game. He offered to her. That's right.
You got any question?
She would have went to jail. And something else. You notice this other detective never talks. So Matt Easter is the only one that talks throughout these entire interviews. You don't hardly ever hear that other one. I mean, you hear him chime in occasionally, like earlier he was like, oh, you got to do this for yourself. Like, we don't know that. Like, everything that they say when these women say something about being clean, I mean, it's a joke. It's an absolute joke. They ought to be ashamed of themselves. I hope they are very ashamed of themselves if they ever watch my show. They should be.
Do you have any questions for me? It is 3:42. It'll be end of the record.
Okay, so that's over. All right, guys, we've been on here 3 hours. I'm going to go ahead and call it for tonight. Tiffany, Matt Easter is no longer an investigator for Kentucky. I wonder why. Well, you know, the one of the state's polygraph examiners got caught playing pocket pool standing outside of a convention, a statewide, like, sheriff's convention or something. It was some kind of a legal uh, law enforcement convention, annual convention or something like that. He shows up at this convention and stands outside of the hotel staring into the camera, the security camera, knowing that those women are inside of the hotel at the desk watching that camera. He knows they are. He walks outside of the hotel and stands right directly in front of the security camera, sticks his hands in his pants, and stands there and plays with himself for a very extended period of time, staring directly into that camera for those women to see him. He knew exactly what he was doing. He knew exactly what he was doing. I've got the video. I've got the pictures. I just never showed it. But I've had them for about a year now. So now that I've had them and I've figured out that we can we can slap a sticker over that part. Thanks, preacher man. Learning. We can slap a sticker over Mr. Pocket Pool and show you that too. He was called out. There was a complaint made on this guy. So the sheriff of the county that they had this conference in was not the county that he lived in. Guess what county this guy lives in? He's right next door, Pike County. He's no longer a polygraph examiner either for the state of Kentucky. Disgusting. But do you think that anybody made an example of him, or do you think that they tried to just sweep it under the rug? Nobody will know any different. I don't remember when this happened. It was before the shooting, so there wasn't nobody trying to get any kind of justice for anybody, and there wasn't anybody trying to expose any kind of corruption. They all just hid it and let him go away quietly. And I guarantee you they probably let him retire with his full benefits. I bet you he did. I bet you he did, because he never was brought up on any criminal charges. All right, guys. I've got the emails. I've got everything for that case. We haven't really looked at that yet. I talked a little bit about it in a show whenever I got it all, but I didn't really know what to do with the information at the time. So, like, a lot of, you wouldn't believe a lot of the stuff I've got. I've just been stacking it up, baby. Stacking. And then whenever we start to write these books, we'll have some tell-all secrets. All right, guys. Thank you, Jesus, for another day being able to come together in your name, Lord. Today's been such a great day, and I'm so thankful. I'm glad that I was able to wake up this morning. My eyes opened. It's a blessing for another day. Every single day, Lord, that I wake up is another day that I didn't think I was going to have. Excuse me. I love you, Jesus. I thank you for saving my soul. I pray that you forgive me for my sins. I pray that you just keep your light at my feet and guide me in the right way. I rebuke the devil and his demons in the name of Jesus. I pray for our house, Lord. I pray that you open the door to my house and my office. In the name of Jesus, I plead your precious blood down over top of that, Lord, that whole situation. Because I know Blessed are those who wait upon the Lord. So I know that the house that and office that you have in mind for me is going to be way more blessed, and it's going to be what I need. It'll check all the boxes, and so I just pray that you help me to wait upon the Lord and know that and trust that you've got it all under control. I love you, Jesus. I'm so thankful just for everything. I'm thankful for your presence in my life, the roof over my head. I'm thankful for this little house that we've got, Lord. We got more love and just good times in this little old house. I'm thankful for it. It's brought us all closer. We've just learned so many things being here. But I pray for the next step in our process, the next step in our journey. Hallelujah, hallelujah. Thank you, Lord. Thank you, Lord. You know all about it. I pray that you touch us each according to our need, whether it be physical, emotional, financial, spiritual. It doesn't matter. The spiritual's the most important, and I just pray that you touch and heal us all and just keep us under your grace and under your mercy, Lord. Thank you, Jesus. Thank you for loving me till I could love myself. I praise you and I lift you up in all praise, honor, and glory. In Jesus' name, amen. All right, guys. Well, you have a great rest of your night. Don't let them bed bugs bite. I had to go get flea and tick pills today. I finally figured it out. I always buy the pills for my dogs, and I hadn't bought one in a while. And my dog's been scratching and itching and going on, and I thought it was going to be allergies or something. And then I looked at Bella, and she had a couple fleas on her. I was like, well, I guess it's time to buy another pill. So we had to go buy flea, and my cats don't never go outside, but they have to have it too. So nothing like a big $200 flea and tick bill. But gotta do it. All right. You all have a good night. We'll see you tomorrow. Tomorrow's big day. With shows. So we've got the video for Lenny Anderson, the guy that was beat up last week. My friend Tony Hall shared it on Facebook. He had a screaming match with the cops up here at their house, and they've got a security video of the entire incident. And he was arrested and taken to jail. And then whenever Tony went and bailed him out, the poor old man was beat to death. His face was just bruised up, something awful. He's on oxygen. He's an old fat man that's sick, and he is on oxygen. You know, he can't walk very well. He's like almost 400 pounds. He's a really big, heavy set guy. And so he couldn't fight too much, you know what I'm saying? But the jail came and got him and took him down there after they bailed him out, and they showed him the video, and they showed them that Lenny was never touched from the time he came in the jail until the time he left the jail. And the girl, Lena Hensley, the supervisor down there, showed them the pictures that they had taken of him when he came in jail, and he had already been beat up, and he had blood on his shirt and stuff like that. She called Jamie Hatton while they were there because they wanted a copy of those pictures. She called Jamie Hatton, who's the county attorney, and asked him about giving them copies of them. And Jamie said no, they were not allowed to have copies of those pictures. The only way that they could get them was through a subpoena. So they weren't allowed to have those pictures that they took at the jail, but I think they were pretty satisfied that he was not beat up or touched at the jail. There's been a lot of rumors went around that he was shaking his appendage. It's waving at you. It's been told that he it's a waving at you at the cops, which, but it was told that he did that to kids. No, he didn't do that to no kids. It was 11 o'clock at night. It was dark. There's video of it. There was no children anywhere around. They don't have kids at that house. That's two old men that live there, single old men. So they don't even have children of their own, let alone anybody else's. So that's not true. Anybody that's saying he was doing this to a bunch of kids, he exposed himself to children, that's a lie. It's a bold-faced lie. And anybody that's saying it, it's just not true. We've got the video. We're going to watch it. Tomorrow, we're going to watch the video. It's a really, really big deal. The cops have made it sound, they've charged him and they've made him sound out to be, some kind of a Chester. And I don't think that it's true. I've sure never heard the first word about him being any kind of Chester. Ever. Ever, ever, ever. And he's been married to a very high-level administrator in the school system for 20 years. So, if what you're saying is true, that he's this big Chester, then you're saying that this high-level administrator has had her Chester husband around all these children the whole time she's worked at the school system? That's a pretty big accusation. That's a really big accusation. And I just don't think it's true. When people are going through a divorce, a lot of things are said, a lot of things are accused, and I just find it suspect that all of a sudden, they're going through a divorce, and the next thing you know, you're hearing all these horrendous things. Well, where was all this horrendous stuff happening beforehand? Because I've not heard nothing about it. I know his best friend is a really, really good person, and everybody vouches for him. His wife is a big time, like I said, a school administrator. She's very well respected in this community. And I don't believe that. I just don't believe that she was married to a Chester for 20 years and that she had him up there at that school. I don't believe that. Now, somebody else wants to believe that. I can't help it. But I don't believe that. And so, we're going to watch the video tomorrow. And we'll just let it speak for itself. I haven't watched it yet. I've been told what's on it, but I haven't watched it yet myself. So we will all watch it together. All right, guys. We'll see you tomorrow. Peace out, Girl Scout. Bye.
Can't hide from hillbilly crime. You can't hide from hillbilly crime. You may not know that there's a crew in town. The head hillbillies are making their rounds. Small town whispers loud and clear. The sheriff shot the judge in his chambers chair.
Sheriff got a secret he won't keep. Judge shot dead in his disbelief. A lot of people have some stories to tell. Dark pass away, get the sound of a shotgun shell.
All the secrets
tales of troubled minds, skeletons covering the mountainside, a treacherous reality in the pines.
Winter reveals the hidden lies. Moonlight couldn't match the cries. Shadows caught in sunlit skies. There's no cover, no disguise.